Medical malpractice cases are one of the hardest type of cases to prove up for a variety of reasons. Unfortunately, there are judges who do not like medical malpractice cases. And I want to tell you about a situation in Iowa and how a set of judges undid a terrific verdict. So in this case, a child was being born, and the doctors and the hospital messed up in such a severe way that during the delivery, they were using a vacuum, which was kind of a way of just kind of sucking the baby's head. They were using the vacuum, and they basically squeeze the baby's head in such a way that the baby is now brain damaged, severely brain damaged. The child is cooked. I'm sure the parties negotiated and tried to settle the case. That did not happen, and the case proceeded to trial in front of 12 jurors, vetted by both sides. The jurors said, "Oh my God, this was terrible," and they awarded $97 million for the pain and suffering and taking care of this child, and I think also punitive damages. And the case went up to the Supreme Court of Iowa. And guess what? They overturned it. I know that's a big surprise. So, on appeal was a question of hearsay. Now, hearsay is an out of court statement that is offered for the proof of the facts asserted. In other words, what's in the hearsay, well, it's not just that it was said, but that it is meaningful. So in this case, the question of hearsay was going forward, and hearsay is reviewed on appeal on an abuse of discretion standard. In other words, some cases are reviewed de novo, which means the higher up court is looking at what happened as if they themselves were making the ruling. But on an abuse of discretion standard, it's a higher level that says, no, we understand that the judges are smart, the sitting judge makes these determinations, and only in the event they abuse their discretion will we overturn the result. Well, guess what the Supreme Court did there in Iowa? They overturned it. They were using the package insert for the vacuum. And a package insert is the same thing that we see in all of our medication, right? Whatever you get, there's always a package insert that talks all about the dosing and what's good and bad and what have you. And I know that almost everyone ignores it except for, dorks like me and the doctors and the pharmacists. So the idea is that the doctors opened up the packaging and know and have received notice of what is in the insert. So they use the insert and trial to say, in these situations, don't use the pump because brain damage can happen. The Iowa Supreme Court said, you know what? We know you had expert evidence, but they didn't pair the same with the package insert, and so we're going to kick the entire case. The good news is that there was a settlement with some of the defendants between a high-low agreement. And real quick, a high-low agreement means that certain parties or all the parties can say, look, we want to cap the highest amount you can get at X and the lowest amount you get at Y. So if you get a zero verdict, you still get Y. You get the highest verdict in the world, you still end up with only X. And so the family did recover something to take care of this very, very injured and very sad situation for this child. And the doctor, once again, will get to go through the entire process regarding his negligence. That's the fight that us who are willing to do medical malpractice cases do. And in this case, obviously, justice deserves the continuing fight. Keep fighting.